Next point is all the other WTO agreements essentially affect border measures, whereas TRIPS affects domestic legislations of member countries and has significantly altered the concept of sovereignty. Private parties claim rights protected under TRIPS within domestic jurisdictions that are referred to as persons of other member countries. Article 1.3 defines persons. Next point is Article 1.1 mandates member countries to give effect to the provisions of the agreement. TRIPS Article 1.1 states, members shall give effect to the provisions of this agreement. Members may, but shall not be obliged to, implement in their law more extensive protection than is required by this agreement, provided that such protection does not contravene the provisions of this agreement. Members shall be free to determine the appropriate method of implementing the provisions of this agreement within their own legal system and practice. TRIPS Article 1.3 states, members shall accord the treatment provided for in this agreement to the nationals of other members. In respect of the relevant intellectual property rights, the nationals of other members shall be understood as those natural or legal persons that would meet the criteria for eligibility for protection provided for in the Paris Convention 1967, the Berne Convention 1971, the Rome Convention and the Treaty on Intellectual Property in respect of integrated circuits were all members of the WTO members of those conventions. Any member availing itself of the possibilities provided in paragraph 3 of Article 5 or paragraph 2 of Article 6 of the Rome Convention shall make a notification as foreseen in those provisions to the Council for Trade related aspects of intellectual property rights, the Council for TRIPS. In the history of IP laws, we observe how the developed countries inter se developed IP rights law over the course of entire 19th century, often violating each other's rights and having differential treatment, and then having evolved their legal system in harmony with each other's IP rights system. This evolved system was then lumped onto the developing world through the TRIPS agreement. In principle, there is no fault with the IP regime developed under TRIPS, but it did not give enough time to the developing world to accommodate and mature to the level of the developed world. No special provisions have been provided to the developing world. Even as far as the least developed countries are concerned, only greater time period for implementation of the same rules have been provided. There is no concession on the rules and principles as such. Principles enshrined in the Paris Convention 1883 included national treatment, right of priority, common rules including patents, inventor having the right to be named, compulsory license, and marks, filing, registration and renewal of marks, industrial designs, trade names, indications of source, unfair competition. Most favored nation treatment principle was also granted under TRIPS, where it included any advantage, favor, privilege, immunity granted by one member country to nationals of another member country is immediately accorded to nationals of all other member countries. Exceptions are provided under the MFN principle with certain subject matters: international agreements on judicial assistance or law enforcement, rights granted under the Berne Convention 1971 or the Rome Convention based on the treatment accorded in another country, rights of performers, producers of phonograms and broadcasting organizations not provided under this agreement, rights deriving from pre-TRIPS international agreements. Articles 3, 4 and 5 of TRIPS provide for national treatment and most favored nation treatment principle. As intrinsic to the TRIPS regime, it also includes substantive standards of protection, availability of IP rights, acquisition of IP rights, scope of IP rights, maintenance of IP rights, enforcement of IP rights, as well as those affecting the use of such IP rights which are protected under the TRIPS agreement. Article 8 of TRIPS recognizes rights of member countries to adopt measures for public interest, to prevent abuse of IP rights, to improve public health, to adopt measures consistent with TRIPS. TRIPS Articles 7 and 8 together provide the rules for interpretation and implementation of the rights and obligations under the TRIPS agreement. TRIPS Article 7 is one of the few provisions which addresses the concerns of developing countries, as it includes in part, apart from technological innovation, transfer and dissemination of technology, mutual advantage of producers and users of technological knowledge, conducive to social and economic welfare, balance of rights and obligations. The main purpose of IP rights protection through TRIPS has been technological innovation, and as a matter of fact, almost all, if not all, technological innovations still happen in the developed world, and stakes were really high for them to have TRIPS enforced through the Uruguay round of negotiations 1986 to 94. For developing countries, TRIPS Article 7 became the saving grace. It is very pertinent that Articles 7 and 8 have been included in the main treaty of TRIPS and not just in the preamble. Thus, this provision is not just illustrative, it is compulsory. Often developed countries, when enter into any kind of bilateral investment treaty or form a regional trading organization involving developing countries, they ensure TRIPS plus or even stronger IP rights regime as a precondition for forming such an association. Patent protection and an incentive of a minimum of 20 years' control over the protected subject matter have been expected to encourage investment in research and development. Though this point is hugely debatable, and there is again a developed world divide, both in terms of approaching the subject as well as in emulating its impact. Though it is widely agreed that such long-term and wide protecting provision has actually inhibited innovation. A very strong IPR regime does not ensure flow of technology to the least developed countries. Under TRIPS Article 7, there should also be dissemination of technology, which is percolation of technology through informal mechanisms. TRIPS Article 15 provides the protected subject matter under trademarks. The protected subject matter includes any sign or any combination of signs capable of distinguishing the goods or services of one undertaking from those of other undertakings shall be capable of constituting a trademark. Such signs, in particular words, includes personal names, letters, numerals, figurative elements, and combinations of colors, as well as any combination of such signs, shall be eligible for registration as trademarks. Where signs are not inherently capable of distinguishing the relevant goods or services, members may make registrability depend on distinctiveness acquired through use. Members may require as a condition of registration that signs be visually perceptible. Copyright provides exclusive rights for fixed number of years, whereas trademarks provide limited rights in perpetuity. Industrial designs are also offered protection under TRIPS.